Good evening, everybody. It is April 7th, and it is 7:30 p.m. And I would like to start with 24R Pembroke Ave. The Board of Appeals will conduct this meeting according to the rules laid out in Chapter 40A of the General Laws of the Commonwealth of Massachusetts, Robert's Rules of Order, and its own particular set of rules entitled the Rules of Procedure, a copy of which is on file with the town clerk. Another copy is available from the clerk at this meeting. This meeting is being tape recorded for the purpose of taking minutes. Once the minutes are approved, the tape may be taken over. Just read the legal ad.
Okay, legal notice, Town of Georgetown Zoning Board of Appeals. Public hearing will be held on April 7, 2015 at 7:30 p.m. at the Georgetown Town Hall in the second floor meeting room. An application has been filed by Brittany Rogers of 24R Pembroke Ave, Georgetown, Mass. Assessor's map 10B lot 73C in the RA zone for modification of a special permit pursuant to Georgetown zoning bylaws, Chapter 165, Sections 9, 78, 79, and State Code Mass General Law 48, Section 9 to modify conditions of a previous special permit ZBA file 94-4, ZBA file number 15-08.
Thank you. Okay. I'd like to introduce the members of the board: Dave Kapnis, Paul Schillen, Jeff Moore, Sharon Freeman, and I'm Jean Tebow, and our associate member is Sean Dean. I think just the regular members are voting right tonight, so Sean's listening. So if you'd like to step up, well, you don't have to step up. You can just go ahead and present your case.
Okay, so we had a special permit that we had issued in 1994 when we first built our home, and what we're trying to do is change the stipulation of the transferable part of it and the non-blood relative. We have a wonderful woman who's been with us for the past 15 years, and we have decided we're going to be selling our house, so we want to advocate in any way to be able to transfer it and advocate for her if a potential buyer even wants her there, but regardless, we want to be able to transfer that. And we know that when we built our house, when we subdivided, we made sure that we fell under the enough land and whatever else we needed to comply with zoning board's bylaws for the multifamily dwelling. So we just wanted those two modifications changed. That was it.
So there's no correspondence for this?
No, there was no new correspondence, nothing.
And are you here for this meeting? Did I hear you say, is there anything?
I'm just observing. I wasn't sure what you might be thinking about doing.
Oh, I know, because actually I spoke to all my neighbors, and I apologize I didn't speak to you.
It's
because
okay. We never see each other.
We
so.
don't. And she's right across the fence.
Can I
but
just
we're
get your
busy.
name?
Sure. It's Jane Boningen. B-O-M-E-N-G-E-N.
I'm sorry, B-O-M,
E-N-G-E-N.
and your address?
It's 3 Partridge Place in Georgetown.
Thank you.
So I apologize. Yeah, we abut with this subdivision, and I did speak to all the others because, unfortunately, like when you send out the zoning board of appeals, like our one neighbor was laughing. She's like, "Oh, I don't care." She goes, "I just didn't know if you were getting an elephant or something because it doesn't say what it's for, you know." So and again, we explained, but nothing's changing outside. The house will stay the same. The apartment's already there, So again, and we set way back. There's nothing else that would be changing. Just a modification. So that's it.
Okay, so you don't have any comment? Okay.
You guys are the owners,
Yes.
and then the person, are they related to you then, or I'm not sure I understand.
She's been with us 15 years. She's a family member, but she's not a blood relative, but she's been there forever.
Because it was, the property shall be occupied by the owners or persons related to them by blood.
Correct.
So it doesn't even say that at this point you need to have someone of a blood relative to be in that property, right? In that apartment?
Right, because when we first built it in '94, when our children were little, we built it for his grandparents who have since passed on. And then my uncle's sister lives with us, so it's not a blood, but she's been with us forever.
I think it's supposed to say both units shall be occupied by, but they didn't write it that way, they said or, so. So be it.
Huh.
Yeah, there's a few things that were a little funny because we didn't realize how they were.
Well, yeah, and this was granted prior to the accessory apartment
Correct,
bylaw,
yes,
right?
because
So-
and that's why, like, at one time, we actually had a little difficult a few years ago when we went to refinance, because everywhere it does say multifamily dwelling, like on the assessors and everything,
Mm.
because back then, there wasn't an accessory, I mean, whatever, the in-law thing.
Accessory,
Yeah,
whatever.
yeah.
accessory
So it was
apartment.
always considered as, so again, we felt nothing really was changing except for the modification.
They did a lot of those in the 90s because the accessory apartment came in 95, and if you look up all the multifamilies that were done, they all say owner occupied and kind of that same thing.
Which we had no problem with the owner occupied. The house is set up, I mean, obviously, it's a raised ranch, it's set up, you would want it owner occupied. It's not like it's a, investment property in any way, It just has a small unit.
Any more questions? You think
How
you're
we
getting
have-
ready?
Me, no, I wanted to, sorry, continue on. Yes, got some issues or questions. So I'm just wondering what the purpose was of having this expire prior to the sale or transfer of the property. So it's a special permit for single family, for conversion to a two-family dwelling.
Correct.
I'm just trying to get at what the purpose may have been for them to want to require this to expire, to transfer the title of property. Generally, the accessory apartment bylaws include this so that the new owner comes before us. If they're gonna buy a property with a accessory apartment associated with it, so that they understand what the provisions of that is. There's a bylaw in here specifically for that. This is not really that case. I mean, I was kind of going around going, why would we want to remove something if there was an intent purpose for it? But where this is not technically an accessory apartment special permit, it's a permit for multifamily. These provisions are gonna be automatically in the bylaw and anything going forward. In other words, if this is an accessory apartment bylaw, somebody came, in other words, what's gonna prevent somebody with an accessory apartment special permit
I agree.
coming before us saying, well, we got one of these, but we'd just like to remove this stuff now. But those conditions are actually in the bylaw now.
Mm.
So it's part of the bylaw
Mhm.
when we grant them. This was not, so it's sort of a different situation is what I'm getting at. Because I know that somebody might have concerns about pulling this out and then having accessory apartment special permit come before us, and they just want to sell it with that. Because typically what they would do in an accessory apartment is, a potential buyer, they may come before the board, the buyer would come before the board with a P&S or something like that. Or after the sale, if that's the case, come before the board for reactivation of that special permit, which would not generally be unreasonably withheld, I don't think, provided they understand what the conditions are. This is not really
No,
the
this
same
is
thing, because it's,
basically, it's the same as being granted a variance for multifamily. If it's carried through to the new
it's not a
set.
special permit, but yeah.
But these days, if you want a multifamily, you can't even get a multifamily now, can you?
Special
Oh,
permit.
sure, yeah, with a special
Oh, with a
permit.
special permit?
Yeah.
Which
As long
again
as the-
ends with the sale of the property? All special permits end with the sale of property, no?
No. That's why they want.
Accessory apartments end with this, null and
Generally.
void once the property is sold or transferred.
How big is the,
The
Not multi-
unit itself,
yeah,
860 square feet.
all right, so it already
approximately.
exceeds the accessory
That's
apartment.
accessory,
Yeah.
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 Mm.
Is that footprint, or that's livable square feet, is it?
That's livable square
Yeah,
feet for the
yeah,
apartments.
right.
and-
Yeah, 450, yeah.
Mm-hmm.
yeah, that's it.
All I'm getting at is I'm trying to distinguish the difference
Oh,
between
sure.
what you have and what somebody with an accessory apartment special permit has, which are two different things, because I want everybody coming in basically wanting to withdraw, remove conditions from their accessory apartment special permits that are there for different reasons, so. Anyway, that's all the questions I have.
Anybody else?
If you wanna just read those exhibits, mark the exhibits, Gina.
Initiatives?
I'm not, again, I'm not really clear whether it was. Yeah, it's a permit to convert a single family dwelling to a two-family dwelling, and then, so you guys are asking simply to remove the portion of condition 1 and remove condition 2, correct?
Correct.
No, I don't, it's clearly a two-family dwelling, so it's definitely different than an in-law apartment.
Madam Chair? Can
John's got a
Oh, yeah,
I say
sure.
make just one comment on that? The
Yeah.
original building permit was for a two-family dwelling,
Okay.
Always subdivided,
so from the beginning it was identified as a
Excellent, thank you, John.
multi-family.
Don't know.
Why would
That's
you
what
need a
Jeff-
special permit
what
for a
Jeff is
two-family?
trying to figure out at the
That's
time.
kinda
Oh,
weird.
so you can tell us, you
No,
built
they
the house,
built
right?
they built it new, and they came and got a special permit for a multi-family, and applied for a
okay.
permit as a multi-family.
Yeah.
And
So
then,
it wasn't
why were the
originally built
conditions
as a
applied in the
two-family?
first place?
I don't really
That's my
know,
first question.
Yeah,
but I exceeded my square footage,
Get it either.
and two families are allowed,
yeah.
and it's based on square footage of the lot, and I exceeded that, and like John said, I applied for that, knowing that my grandparents were gonna go with me, and then at the time, I don't know if they felt that my grandparents were with me, and they wrote in the,
Oh, so then it became sort of it's two-family / in-law, but it's not really an in-law. That has nothing to do with it.
basically.
It was always a two-family,
Yep, yep.
and somehow it was
Oh, just
interpreted
these
to be an in-law,
Where's the,
accessory apartment.
Special permit.
Do you have a copy of the decision, or do you want me to rip this one out?
It's right here. It's with your packet.
Oh, I know, but to mark it.
I have one marked right here.
Oh. What did you want me to read these in?
You have to read them into the
Oh,
record.
I
That's
thought
all
you wanted
the
me to
new-
mark them, I'm sorry.
When I say mark them, I mean
Read them?
read them into the record. That's the new open meeting law.
So just read them out, or with the motion?
No,
Okay.
no motion, just read them
Here's
into the record.
the exhibits for the hearing for 24R Pembroke Ave. Can I read these, or, okay? Because I'm not supposed to read certain things.
You can't make a motion.
Previous decision number 94-4 will be marked as Exhibit A. The plot plan, foundation certificate plan by Lewis Holt will be marked as Exhibit B. The first floor layout will be marked as Exhibit C, and the second floor layout will be marked as Exhibit D. That's that.
Need a motion on this?
Yes. Any more board discussion?
I'm just curious, how was it assessed?
It says on the assessors, I thought multi-family dwelling, yeah, it always says, that's why I said, when I did the banking, I had a hard time with bank, so.
Okay. So that probably means there are still 46 multi-unit units livable in Georgetown.
Just bear with us for a second.
Microphone.
Nah, I just don't want to do this.
Anything else? Anything else?
I would recommend that this first condition be reworded to say that the property shall be owner occupied. Simply.
Okay. That makes sense. Just a little bit.
But the owners of the owners of the property shall occupy at least one of the dwelling units.
I agree.
Rewrite after West Hills.
Sorry, bear with me just. Okay, I move that the zoning board of appeals grant a modification to a previous special permit, ZBA file 94-4, recorded with the registry book 12604, page 263, marked as Exhibit A, by rewriting condition 1 to say, the owners of the property shall occupy at least one of the dwelling units, and removing condition 2 that states the special permit shall expire upon the sale or transfer of the title of the property. Further, I move that the board find that the applicant met the special permit requirements under the zoning bylaw, chapter 165-79, sections A through D as follows: that the application is desirable to the public convenience or welfare, will not overload any public water or other municipal services so as to unduly subject any area to hazards affecting health, safety, or the general welfare. 3, will not impair the integrity or character of the district or adjoining districts, and 4, will not cause in excess of that particular use, which could be detrimental to the character of the neighborhood.
A second. More discussion?
She's supposed to say
I
that.
know.
Would you, any discussion?
Once a chairman, always
I
a
know,
chairman.
huh? You can, you
Oh,
want.
I'm sure I'll be
All right.
back.
Yeah, you'll be back. Okay.
No, I think it's,
So.
Yeah, I'd like to
was
say-
that clear, Patty, as worded?
I did it differently, so I need to see what you wrote.
That's
Yeah,
fine.
I reworded
Yep.
what.
Yeah,
So,
you didn't
Oh.
like mine.
Okay. We don't have to do roll call.
kind of
Okay. Roll call. David?
Yes.
Yes, please.
Yes.
Yes.
And I vote yes as well.
Thank you very much.
Thank you.
Thank you for that.
Okay,
Motion carries.
just read the 14-day.
I gave it to you. The zoning clerk has 14 days to file a decision. Any appeal of this decision shall be made pursuant to Massachusetts General Laws, Chapter 40A, Section 17, within 20 days after the date the notice of decision was filed with the town clerk. An applicant may file this decision before the 20 days, but does so at their own risk.
Thank you.
And we need a motion to close the hearing.
I'd like to make a motion to close the hearing.
Second?
All those in favor?
Aye.
Hearing is closed.
Thank you.
Thank you.
Look at
Debbie, on the decisions written,
Is that clear?
you know? Okay. I'll send you, give you instructions. Hold on a second. I can get the money.
So technically, we've already opened this.
Correct.
No one considers it very quiet, they don't see the van, you just can't block that.
Do you want me to sit? No, you can sit next to Richard.
It's already been read once.
Oh, yeah, we've already
you can-
opened.
Yeah.
We don't have to reopen, I think, we're just gonna reopen the meeting, correct? We
Just
don't have
review
to.
that.
But we already opened the meeting, let's open
So you,
the hearing.
yep, you can, if you wanna waive the reading and leave that, you
Yeah,
can
we
do that.
probably read it once.
But
It's up to you.
Yeah,
people
I'll
who
read it.
weren't,
Okay, you
if
read it.
anybody wasn't here.
Go ahead and read it.
So we're reopening the hearing for Three
Three
Farm Lane, right?
Georgetown, Mass.
Right, a public hearing will be held on original meeting, public notice of the public hearing will be held on March 3rd, 2015 at the Georgetown Town Hall, third floor meeting room at 7:30 PM. An application is being filed by Sandbro Fabrication and Coatings Corporation, care of Mr. Richard Duska, located at 3 Farm Lane, Georgetown, Mass. 01833. The applicant has filed this appeal as a party aggrieved by the determination of the building inspector by letter dated 12/1/2014, in which the building inspector has instructed the applicant to file for a modification of site plan approval. Since not all of the conditions were met, site plan approval was approved by the planning board in April of 1999. The property located at 3 Farm Lane, map 20, lot 68C, in the IB zone. The applicant is also citing an issue with previous occupancy permit in August of 2000, the statute of limitations, Mass General Law, Chapter 40A, Section 7. The applicant is appealing this determination to the zoning board of appeals. Is anyone aggrieved by determination of the building inspector or the zoning enforcement officer has the right to appeal to the zoning board? This appeal is pursuant to Mass General Law, Chapter 48, Section 7, 8, 15, and 17, and the Georgetown zoning bylaw, Chapter 165, Section 98. The 1999 site plan approval decision issued was pursuant to the Georgetown bylaw, Chapter 165, 83D, Section 6. Site plan approval, ZBA file 15-07. This is advertised in the Georgetown Record on February 6th and February 13th, 2015.
Thanks, Joe. Okay, the voting members tonight are Sharon Freeman, Dave Kapnis, Paul Schillen, Jeff Moore, and I'm Jean Tebow. And this is Sean Dean, our associate member. I'm having a hard time talking tonight. So, applicant presentation, or do we talk about?
I
New
think the,
correspondence from town council?
That,
Madam Chair, I have a presentation on that, so why don't you, I don't know if you,
I think I'll allow an introduction from their
Yeah.
request there, let them present what they want to pursue, then we can start from there. Because we haven't even really been
You have
briefed
the-
on the situation.
You have the email on it. About
yeah,
so
I mean,
you're
yeah, I mean.
familiar with the email we
Yes,
received?
yes, kind of the elephant in the room. So,
Right.
Attorney Mitchell Croner, I'm representing the applicant, and to my immediate right is Jack Flimp, who's one of the vice presidents of Chimbro. And I finally learned how to pronounce it, it's Chin-Bro.
Sorry, I mispronounced it.
That's all right, I was doing that too. And Richard Brescia, who has come down from Maine, is also a vice president. Just by a little background, the company, you may recognize the name, they were the company that built the Groveland Bridge over the last couple of years. And a couple of years ago, they bought this Farm Lane property from L.W. Foster. And Jack, when we get a little more into the substance, can speak to that because he had worked for L.W. Foster, so he was involved when this whole site plan and the prior addition went in. I've made this speech before, maybe not to this board, but I've been doing this for 35 years in Georgetown, and I live in Groveland, but I'm very sympathetic to the members of this board, my clients, the residential abutters, and my friend the building inspector. And John is sitting up with us. I'd like to call this a friendly appeal because we've been trying to work with him for several months, my client has and I have, on this. Unfortunately, and you faced this before, we have a situation where we have an industrial zone abutting residential property. And over the years, the town has, and Jim Rogers, who probably has been there longer than any of us, since his family owned this property, it used to be just a nice swath next to 95, and over the years, the town meeting has taken different properties out of the industrial zone for residential use, realizing that that really wasn't the best way to zone for industrial because there was no good access. You know, some of you are probably familiar, we now have the access road on the other side of 95, next to Longview Apartments. But that's kind of the background. The reason we're here is there was an abutter complaint about a year ago regarding noise from this business. Again,
Gotta push real hard.
Again, unfortunately, light industry, which this falls under, the company has been there, by the way, since 1989, so it's been there, a long time. Light industry is defined as fabrication, assembly, processing, finishing work, or packaging in such a manner that noise, dust, odor, vibration, and similar objectionable features are confined to the premises. Now, I have a hard time believing any court would enforce that definition, especially for this type of business. I mean, the town allowed the predecessor to Chinbro, to my client, to be there, and, we can argue all day long, but the noise just cannot be confined to the premises. So there was a complaint, and again, I will get into, my client has tried to make various remediations. I don't want anyone in the room to feel that they've ignored this. They've spent money. Mr. Klimt can describe some of the improvements and modifications they've tried to make. Subsequent to the complaint, John, doing his due diligence, which he ought to do, came across the fact that in his opinion, the site plan that was approved was not the same that was on the ground now. And, he and I have been discussing this for several months, and we just couldn't come to an agreement, so we decided it would be a good matter for the board, because I think it establishes an important precedent either way. Not just the building inspector, but any aggrieved abutter anywhere in town could go in, look at a file 15, 20, 25 years ago, and, ask that the site plan go back to the planning board. So that's kind of the overview. The issue that John Eichman referred to today, unfortunately, in terms of statute of limitations issues, in terms of timeliness of the appeal. So I know you have some of these documents. I know Patty likes everything ahead of time, but obviously that didn't happen here. So I think I've got enough copies. Yeah, you want to just pass that out. I can take you through the history of the dates. And John,
Hey, just so you guys know, you have all the letters.
I think you probably have, you may not have a couple, because I put a couple of my emails in, so you may not have those.
These are all the letters.
Do you mind, does someone mind sharing? I just would like to give John a copy, actually. Does someone mind sharing? Thank you. All right, so the first issue I want to put to rest is whether we were timely from December 1st. So the first exhibit, if you will, is the envelope that was mailed to me by John to my home office. Letter was dated December 1st and postmarked December 4th. I received it December 5th.
When was the first one tonight? Fourth?
I'll repeat it. That's all right, we've all done that. So John's letter was dated December 1st, mailed December 4th. I received it December 5th. So the 30 days would be, under the 30-day rule, would be January 5th. So just to back up on the calendar, January 1st was a Thursday, New Year's, the town hall was closed. January 2nd, a Friday, the town hall was closed. January 3rd and 4th were the weekend. So I filed it on Monday, so it's date stamped January 5th. So one of the next page John basically says in the email, I agree with that with the holiday closures, an extension of time would be appropriate. I agree if you get the package in by the end of the day today, January 5th, which I did, an extension is not required. If that is not possible, I would be willing to extend the appeal window 7 days. So that should put that issue to rest, in my opinion, that from December 1st, we were timed. As far as the other issue, I can go through each page, but basically this started March 3rd, 2014, and was just a series of back and forths with John. John was operating in good faith. My clients were operating in good faith. I came on board in September. John and I discussed me writing a letter to him, which I did on October 15th. He responded on December 1st, and basically he and I decided that we would appeal from December 1st. And again, John, if any of that's incorrect, please inform me. So there's been a series of extensions. Some were requested by Jack Klimp. Some were requested by Hannah Bass, who works for Richard. And all this was going on, the company was trying to make modifications to the noise situation. And again, the noise really isn't before you tonight. Maybe unfortunately another night, but it's not really before you tonight. But I think it's important in the board's decision that this is not a company that's just saying we're not going to do anything. You know, they've spent considerable sums of money trying to alleviate as best they can a noise situation that cannot be fully remediated. So why don't I stop there and, you know, maybe answer any questions the board may want to discuss. I guess in summary, I would say I think it's an important issue. I'm a little disappointed with town council that he raised that. I mean, certainly on an appeal, de novo, he could raise that as a, you know, defense in representing the town. But I think in terms of this board, and John can correct me if I'm wrong, I think the applicant and John, I think this would be a good matter to have adjudicated by this board so that going forward, as an attorney that does this type of work and the building inspector, you know, can a site plan review be reopened? That's really what we're here about. After an occupancy permit has been issued, after 15 years have passed, after a new owner has bought the property. And again, I'm not finding any fault with John. He just felt this was important for this board to rule on. I might add, to my knowledge, and Patty can correct me, I don't think there's been any correspondence from the planning board other than one of the abutters, Mr. LaCartiglia, who on the planning board, but he wrote the letter clearly as an abutter.
He submitted a letter as a citizen, yes.
And, you know, the planning board had full knowledge of this hearing. I never got a call from Howard Snyder. I guess, quite honestly, I don't think they're too concerned with this. But, you know, I guess that's enough of my introduction.
If I can, I did speak to Howard, and he just said it, you know, the board didn't feel it was appropriate because it was a hearing that you had to either agree with the building inspector or not. So they didn't think they could. And that's just what Howard had said to me.
Ask a question?
Yeah.
So I think the key thing, and it's obviously we have to first decide whether or not we feel we can hear the case based on the town council's opinion that we received.
Right.
He's
Right,
pretty
yeah,
strong
yeah.
in his opinion.
Yeah, I mean, I have, that's not my that wasn't intended.
No, I
That's
know.
my-
From a board standpoint, before
Yes.
we get into anything
Right,
else,
I understand.
don't mean to
Yeah.
step on your toes.
No, I was
This
just
is,
thinking of how I was gonna word it. Go ahead.
But I think the board has to figure out whether or not we need to consider the opinion that was given to us just today as well, because a lot of us were doing some homework, to try and sort
No,
some
I
things out.
understand.
And there were quite a few, not quite a few, there were a few questions that we raised over the last several weeks, none of which had to do with the timing of the appeal, by the way. And this is what he stumbled upon, or determined, I mean.
And in
So-
fairness to the board, I realize you're all volunteers. When I first saw this morning, my first thought was to come in and ask for continuance, I guess in fairness to the board, because, you know, I know you all have day jobs, and if you didn't have, you know, this was my job, so I did read it this morning, but some of you may have not. Some of you still may not have read it. But talking to my clients, and we just decided we'd go forward and,
This is an important issue for us. I mean, we want to be good partners with every community we're in. So it's an important issue. It's nothing that we want to try
I'm sorry,
to,
your name, sir?
Richard Bruscia. So we don't want to ignore it. We want to try to figure out what the best possible way to go forward here is. But we do have to operate our business at the same time.
Right.
so that's why we didn't want to ask for another continuance. You know, they want a resolution one way or the other. And I realize that may put some of the members who haven't really read John Eichmann's,
Well, I think I'm speaking for all of us, and correct me if I'm wrong, I think we've all read it.
okay, all right, that's
Um,
fine.
We did make sure that we all knew that there was an email that was very
Okay,
important.
all right, that's fine.
And I feel like our hands are a little bit tied, and this in no way reflects my opinion on what I think you need to do or what you've already done. But I struggle with doing something that I've been advised not to do. We've been told that we should deny based on the timeliness.
Mhm.
And whether, and again, none of us were looking for that. We were asking questions to help us alleviate the issue that came up. And in my opinion, I feel like if you were to go to site plan, not to be responsible for phases 3 and 4, but to propose whatever you would propose to us tonight as a site plan, and ask for approval through planning, I think that would really be the best course. And this is just my opinion. Because that's really more their jurisdiction anyway. We're zoning. We hear the zoning issues. We don't necessarily hear all the site plan issues that they would deal with. So that's kind of just.
Yeah, I mean, and in fairness, Madam Chair, what you talked about is exactly what my presentation is going to address, why we don't have to go to planning. So we're kind of in an awkward
Okay,
situation here.
Can I ask you a
Sure,
honest question?
Yes.
Why do you not want to go to planning?
because we think it would be certainly a waste of financial resources that could be better spent between my fees. They would have to hire an engineer, they would have to pay for the review engineer, Larry Graham. It would just be a lot of money spent, and I think even the abutters that wrote the letter were saying that maybe more trees should be planted, and maybe that would help reduce the noise, but we don't really know that. So there really isn't, I think it's a bad precedent. I have some material from Mr. Bobrowski here that says, site plan review can only be used to shape a project. I mean, it's pre-construction. It's not a special permit. It's not meant to be revisited. I have a letter from the planner in 2000 to the building inspector with this very issue. So, I mean, to me, and now I'm making my argument, that for the planning board to come back, to make an applicant 15 years, 20 years, 25 years later, if there's no limitation, plus 48 section 7 that puts at least a 6 or 10 year limitation, that's out. So I think, Madam Chair, I think what the board needs to, do they want to deny based on town council, and then we appeal, and then if we win, then we gotta come back on the substantive issue, or do you, I guess, note his opinion, but go ahead and hear either my arguments fully why, I think to me, if you read what I just gave you, what he's questioning is whether John has authority to grant extensions. That's really what it amounts to.
Right, on the timeliness issue.
Right.
Well,
He didn't question it.
there's
I
actually,
think he made it clear that I do not have the
Yeah,
authority
he
to
did.
grant
I think-
extensions.
I
Nor do we.
think you're asking us to make a decision that, you know, we're uncomfortable with because we have advice from town
Right,
council.
right.
That clearly states
Mm-hmm,
where we should be, as a board,
mm-hmm,
you know, not to overstep our authority.
mm-hmm.
And I don't think that you can present any argument, at least to me tonight, that's gonna convince me
Mhm.
that I should overstep the advice we have from town council as a representative of the town. I'm sorry, guys, you know, I know this is, you know, not what you wanna hear tonight. And I emphasize with you guys about, you know, what you're going through, but we stated right up front, our hands are pretty much tied. Okay, I mean, I'm not speaking for the rest of the board, I'm speaking for myself, but I can't sit here tonight and say I'm not gonna take town council's advice, because he didn't suggest it, he made it very clear, the authority is not there. John doesn't have it, we don't have it, I don't know what else to tell you.
And honestly, I sympathize with you. I'm a big proponent of business in Georgetown, and I don't want you to feel like we want you gone or anything like that. I feel like there's gotta be an easy way to do it. Maybe it's not site plan. I'm not sure. But right now, I don't think it's through us.
I mean, unfortunately, what we're gonna do is take an appeal on a strictly procedural issue. It's gonna cost the town money, it's gonna cost them money, it's not gonna help the abutters at all. If we win, then we come back here again, appealing John's decision to site plan, whether we have to go or not. If we lose, we can appeal that again. And, you know, I think it's just, it's a waste. I understand your position. I mean, your position, I mean, I could argue for 3 hours. That's why I want to, you know.
Not gonna happen.
Right,
Not gonna
right.
happen.
So if, you know, I think he's wrong. I think if you read, I think a judge is gonna agree with us.
And that's great.
And, you know,
But that's not our authority
Mhm.
to overrule the advice we've been given.
Mhm.
I would love nothing more than to see you guys come back, say, hey, you know what, we were right, we won. Let's talk about planting trees. Let's talk about insulating the walls abutting the neighbors, okay? Let's talk about, you know, reducing whatever you can do,
Okay.
okay? Because we all wanna see you here. And yeah, you know, we know, bottom line is, you bought it after all this stuff happened. And now there was another glitch with the filing, you know, the appeal date. We're handcuffed. There's nothing we can say tonight.
all right, so what I want to do
And
then.
just so you know,
Yeah.
my question was, can we even hold you responsible for something that happened before you were even there? Because that's
That's all we
that's
ask.
how this all triggered it.
Right,
Because I said,
right.
how can
That's
we
his
hold them?
argument.
Right.
And no, and so understand, like that
the
was my
to
question.
town council.
Right.
I said, how can we hold them responsible for something that they weren't even the owners of at the time? Because I wanted to do what's fair. I want to always do what's fair. And he came back with this. And like I said, I'm so sympathetic to you that I just feel like there's nothing else we can do. And I understand the whole appeal process is going to cost money, but I feel like if you just the easiest thing to do is just go to site plan and don't spend all the money to do what you need to do. You're going to tell us the same thing. Can't you just put it on a drawing and
We'll
bring
take
it-
that under advisement. But I
I mean,
mean,
you're gonna
I mean,
spend
it's
all this money with all
unfortunate
these
because
appeals.
if we had come here in March and hadn't asked for the continuance
Mm.
and taken our chances with 1, 2, 3, well, sorry, Jack, 1,
Yeah,
2, 3, 4,
Right.
you wouldn't have had, so I mean, there's a whole
And
series.
you know what? Who knows what would have happened?
Yeah, well, that's what I'm
You
saying.
know.
I mean, I gave them the best advice that we needed 4 votes. And again, I wasn't trying to be disrespectful to any of you 4. It's just that that was the best advice to wait a month, you know. So
Let me-
here
let
we
me ask
are.
you, Mitch, there's really 2 things that are driving this opinion that we got today. That's really what we gotta get,
Yeah.
either get over it or
Right,
move on.
right.
There's 2 things, and I guess he's kind of delineated the fact that you know, the 5th, or whether it was the 31st, and all
Yeah, I think that, to me, I'm hoping
Now,
that,
it seems to me, and I'm not an attorney, that you've got a pretty clear argument that you think it should have
Yeah.
been the 5th.
Yeah.
I don't know. I have neither had the time or I don't have the knowledge
Yeah,
to agree
yeah,
or disagree with
yeah.
you on that. The other thing is whether or not, you know, he's stipulating that what you're really appealing is something that happened much earlier in the process, some correspondence that came from John much earlier, which clearly the argument you have about the date really wouldn't apply because.
Oh, yeah, no, that's, no.
So, and I
agree.
think you have an argument for both. The question I have is, I mean, you could continue and you could take it up with town council and basically through a campaign of contacting him,
Mhm.
see if you can get him to change his mind a bit. I mean, frankly, I mean, it's another option if you wanted to continue this.
I mean, maybe that's,
I mean, we're not, I think the reason we feel our hands are tied is because we're not experts in this nuances of the, in this stuff. You make your eyes glaze over, honestly. I mean, we're here to
No, I
do the substance
understand.
of the
I
matter.
understand.
And we're stuck. I mean,
Well, we don't want to set
frankly,
precedent for
if I
allowing-
wasn't taxpayer town to just spend whatever we spent on town, if we do this all the time and just ask town council all these questions, we don't like the answer, we just ignore it, well, that doesn't go over very
no,
well,
I understand,
frankly.
I understand. That
It's-
certainly makes sense.
And I've been on this board quite a while, and I gotta say, I don't ever recall reading an opinion from town council that was quite as affirmative as this, to be honest. Usually they're kind of, well, I don't know, you should, maybe you should,
It's up to
I
you
don't know,
guys.
it's kind of really, I mean, not to, but that's how the stuff usually comes back. I read it this morning, and
We
really,
were as
seriously?
blindsided as you.
Yeah, I mean,
Yeah.
maybe my first reaction at this morning at 8 o'clock, or whenever Patty said, whenever I saw it, or John sent it actually, was to ask for a continuance, and maybe that's the logical thing.
I'm wondering, can you,
I mean,
honestly?
if you
can
vote tonight,
You got the biggest dog in this fight, maybe you can talk to them. You've tried briefly.
yeah,
but
I mean.
you were busy today.
Yeah, I mean,
and
in
had to
fairness to
chit-
John, we had a couple emails going back and forth, and he did say in the last email if I could produce something, but, obviously there isn't time,
Need
so
more
maybe,
time, yeah.
I
I
know
don't
these
even know if
guys
that's an
aren't gonna
option.
be happy, but I think rather than, if you vote tonight, we're gonna appeal it. And maybe the fairest thing is I hate to drag the abutters here again, but maybe continue it a month.
You can't withdraw, that doesn't help you.
No, so I think the board, we could certainly request a continuance.
They have
I've
to
already
wait.
signed an extension on the
And you have to
date,
vote to allow a continuance.
and at least give John and myself some time. If I can't budge him, we'll just come back and, you'll do, and I understand what you're saying, he's your attorney.
Right.
Maybe I'm right, maybe he's right.
I'm sure this can't be the first time this has happened either. I bet you there is cases where it's
Well, he said there wasn't.
really.
Yeah.
Well, then you'll be the first one.
But that
Because you're perfectly
Doesn't mean
reasonable
you
what you're
won't find
requesting.
something.
That's what this board is famous for, is
Yeah,
figuring out what's
yeah.
reasonable. And
Mhm.
could I? Do you want to vote on this? Can I ask a general question?
I just,
Yeah,
our
yeah.
extension, is our extension long enough
If
for
you want,
another?
we'll sign another one.
Well, and I'm asking that, so yeah, we don't have to come back in.
We filed an extension to June.
Wasn't it June?
No.
Here it is.
I have a question
June
for
2nd.
John.
June
Okay.
2nd.
So if you want.
Yeah, it is June.
Okay. So that
So I
was
think
on
we'd be
that.
all right if we continue this to May.
Can the abutters speak before a decision is made on that? Is that something that are potentially speaking, would affect your vote? I mean, are we gonna have an opportunity to speak?
Yes,
I
it will.
You will for sure,
But
but
it's-
it won't affect anything tonight.
Yeah,
Well, unfortunately, there's the rules of how a meeting is run, and we're not even going to get to the second step in how this meeting is run right now. If we determine this conversation maybe shouldn't even have gone as far as it did. We should have just decided right away. It was just them trying to impress upon us that we should leave this hearing open, and that because they didn't make the deadline, it was not a mistake. But am I being clear about that?
Did you make sure, excuse me, that I don't think you don't have a copy of the town council opinion, do you?
No.
I mean, in fairness to them.
Yeah.
I'm not even sure they know what we're
Absolutely.
talking
I guess
about.
someone could.
He-
You want to
he-
clarify
I
what?
think he
We're not
said that we
marking that
are
in.
marking
Not
it as
public.
public. It's,
You're arbitrary about whether.
No, but we can,
we can
I
quote,
asked if it's gonna be marked as an exhibit, and I was told
he
no.
said no.
You said no.
He said that we can quote parts of it and use what we need to, so we could read something.
Something.
I mean, we have no objection for that. I mean, if you don't want to release it, but we have no objection.
let me just, I can quote the crux of the matter is that in town council's legal opinion, the Board of Appeals must deny the appeal before it filed by the owner of 3 Farm Lane because the appeal was not filed within the time required under Mass General Law, Chapter 40. And then goes on to explain why. He's arguing that they did not file their appeal in a timely.
It's a
They were-
technicality,
They
so-
were late by a few days. Further, he goes on to say that even if you were successful in arguing that it could have been the 5th instead of the 31st, what you really were appealing is a document issued by the building inspector, and I don't know what
June
date.
7th, I
June
think
7th.
17th letter.
Yes,
Right.
Okay.
in my hand.
Yep, that's
That's
the
what I
one.
wanted to ask about.
And
I
that's-
understand.
Yeah, the only thing that I fear, but no, I don't really fear, but whenever we continue something also, it kind of gives the applicant the impression that, you know, hey, let's get to the next step and then we'll be able to work this out. I honestly don't know what my opinion would be. If you're successful, then we're gonna start talking about the facts of the
Yeah,
case,
yeah.
and I've got a lot of questions there
Oh, I
as well.
understand,
So
I
just
understand
wanted
that. I mean, this is unfortunate.
At least you got your day in court, you
Right,
know.
I mean, in a way, we've wasted whatever, not talking about the issue.
Right.
Right.
But I understand fully your position.
So Patty, what were you gonna say?
Oh, you had a question?
Oh,
I think it's
No, I'm,
sort of been addressed. Could I have a clarification on the, how many letters have gone out and how many 30-day deadlines have been missed on appeals?
Well, depends.
And that's what
Yeah,
right, I'm going back to
I would like to read into the record, just so we have it. I was gonna, just if I can, I don't know if you wanna mark each letter or how you wanna do this.
Gina
or-
has, we have all
That-
the letters between you and John.
I think you have
And the plans, and they're all set up.
a couple of my
have
emails
to
you
read
don't
that.
have.
We have to read those into the record, that was.
Tonight?
Yeah. If you read town council, when we ask the other questions, he said he needs to mark everything in
Okay.
exhibits, so this will be exhibit, if you wanna write it on there, it'll be R.
And is this where your email
I'm just
is?
referring to this packet.
Okay.
Some of the
Yeah.
letters you have, it's just,
So someone
Yeah,
needs
this
to
is
read that into the
In
record
relation to the topic at hand.
I mean, I think
before you
Mr. Shilham
vote
raised the
or close or
question,
whatever.
how many extensions and so.
Well, they're all listed.
I mean, I guess if we're gonna continue it, I guess I don't have to read it, we can.
Well, that's what I'm
The
wondering.
board is-
If-
Oh, it's
You
not
were-
If we're
really
gonna
on, I
continue
guess.
it, why don't we read this?
There were several.
It should be read.
There were
It
several.
was already, that issue
He
is
said it
will be
in-
discussed later as
Yeah.
far as what was appealed on time and is correct, like, obviously there was some ongoing communication, John, between you guys, so there was, at some point, there was a final, they were given the ability to have 30 days to appeal. At what point did you decide that this was the deadline?
Yeah, I mean, it's been a moving target, to be honest.
Yep.
You know, March 3rd, the first letter went out. You know,
And it said.
shortly
yeah,
after, that was a noise violation of the
Right.
zoning bylaw noise complaint. And then it wasn't until June timeframe that I had pulled up all the site plans and we went through that process. Now, in all that time, I was meeting with the butters, I was meeting with the officials at the facility.
Yep.
They were doing some, it was back and forth, noise testing,
Oh, really?
it's,
Did they formally appeal your decision back in March?
no. There was no-
Probably should have
so-
been, right?
And Attorney
Yes.
Croner was not part of the whole discussion until
Right. All right, so.
later, much later.
Yep, I understand.
I mean, again, in answer to that, I mean, I'll just read this. In the March 12th letter, Jack Klimp, to my right, responded to the March 3rd letter saying, to the extent this letter can be considered an appeal under section
Yep.
16598 of the zoning bylaws, please do so.
Yep.
Now, I trust John, I wasn't even involved then, but I think if John felt it was a 30-day appeal period, he would have told them they need to appeal to this board. So I want it clear on the record, John thought he had authority to do this.
Right, yeah, I understand.
I thought he had authority, the applicant did, only town council, and he might be right, and again, I know you have to listen to him, but I want it clear, John was operating under the same, that we were going back and forth, they were making some changes, they planted some trees, they changed alarms on the
Lift trucks.
lift trucks, so I mean, it was an ongoing procedure, and I think John and I just kind of reached a point where
We need to
the Board of
formalize
Appeals
this.
decide
Yep, yep.
that issue,
Yep.
and while the company would still try to mitigate noise as an ongoing, since that really is kind of the real issue.
Right, it is, okay.
So, and John did not do anything to mislead us, to mislead them before
Right.
I was involved, so
Yep.
I think John Eichmann's looking at it one way, and, I realize if the town goes to court, John's gonna have to be in the town side, but, I think he was looking at it the way we were, that it was kind of an ongoing process, so.
Yep.
I want that clear.
And can I just,
Sure.
to close that out, I think, and I don't, again, not to deviate from the issue that we're talking about, but the December 1st letter is technically the one that you're appealing.
Right.
Specifically, what part of that opinion you're disagreeing with his determination? And I, without getting into the argument of the case, I'm
Right.
trying to understand, just so it's clear. He states, it's my opinion that the building inspector, as a building inspector, I do not have the authority to modify or
Right.
waive any conditions imposed by the planning board. Is that what you're appealing? Is
Yes, see, and that
you
really,
disagree with that statement?
I don't
Is it-
think that was in any of the prior letters. That's another one of our arguments, that is his opinion. He was telling them to go to the planning board. Then I write a letter saying why he has the authority that we don't have to go. He writes back, which was fine, saying that his opinion, he does not have that authority. And that's what we're appealing. So, that's another one of our arguments, that the real crux of the appeal is in the December 1st letter.
Because all we could do if we were to hear this case in full is to either agree or disagree with
Correct.
John's opinion.
Correct.
I don't know that this board necessarily has the authority to sit down and say, okay, well, say trees over here, and,
Yeah.
Again, I don't want to get too far into it, but I just want to,
Right.
we're going to get to the point where we're just going to say, yeah, we think John's right, or.
Right.
you
I mean,
know,
frankly,
yeah,
that was
okay,
part
so
of my-
Go on your way and work it out with him.
It's like the
I guess.
speech I had yesterday, I tore up, or put on the shelf. But I was gonna try to keep you away from looking at the plans and just a narrow issue, occupancy permit, new owner, statute of limitations. You agree with me, you agree with him, and that's it. I don't think it was involved. I know you've been very, Patty kept writing me, they want, I know you people have done due diligence on this, just I can tell, that you really try to understand a very complicated issue. But that being said, I guess we would request a continuance for me to talk to town council, and with the understanding, if he doesn't change his mind, most likely you'll vote to deny it at the next meeting. And then, I can't speak for them. I would recommend an appeal.
I don't have an issue with that. I kind of brought it up as not that you wouldn't
Just so
have asked
you
for it
know,
anyway,
I
but.
have to ask Mike if he's gonna send anything else to town council if we continue it.
Any
know how that's
correspondence
gonna-
to town council has to come to us.
Right, no, I understand. No,
He
yes.
might not
And
yeah.
he may say, forget it. I don't know. I'm just telling you, as it is tonight, we're sitting here.
No, he
And
made
I'm
that
trying to
clear.
give you another,
He gave me my one, he gave me my one free email,
yeah.
so I understand, no, I know how it works. I understand.
We need to make a motion to grant,
To continue,
continue to, we have a date.
May 5th,
Is that right, Patty? May 5th?
May 5th,
it's on our packet.
immediately following the first hearing.
I'd like to make a motion to continue this hearing to May 5th, immediately following the first hearing.
Second.
All those in favor?
Aye.
Opposed? Carried.
Okay, thank you,
guys.
thank you,
Good luck.
thank you.